Matter of Menza, a couple of weeks ago out of the board, another case about fraud or willful misrepresentation, such that an individual is inadmissible. In this case, Miss Menza, she got a conditional green card at a USCIS interview through her first husband, and then tried to remove the condition, but by that time she had already had a child with another man who ends up being her second husband eventually. And it seems like she wasn't so straightforward during the interview to remove the condition. And she wasn't living with that second husband yet. She wasn't living with that first husband anymore. And USCIS denied. They refused to remove the condition. But they didn't make a 204C finding, I mean, they're essentially saying that you didn't prove the validity of this marriage, but that is essentially a 204C finding, which would then bar her from ever being the beneficiary of an I-130 again. Instead, they put her in removal proceedings, as they would do. And in removal proceedings, Ms. Menza, as she could do, instead of trying to remove the condition on her first green card, she applied for a new green card through that second husband after USCIS approved an I-130. Again, they approved the second I-130, so there is no 204C finding. But then the judge found Ms. Menza inadmissible and therefore ineligible to adjust status because she had tried to procure that first visa through fraud or willful misrepresentation. And here the board is saying that that is fine. You can do that. You can use fraud or misrepresentation at a interview to remove a condition to sustain a 212A6CI finding on a different adjustment application. And you're allowed to do that. And, she seems like she misrepresented some stuff at the interview, but 212A6CI requires that it be material. And the board and Supreme Court a bit, although the Supreme Court the board is relying upon is actually not in the inadmissibility context, it's in the DNATS context. But what constitutes materiality has been getting watered down over the years. And now it's essentially if the omission or the statement would have led a reasonable adjudicator to essentially ask more questions, that makes it material. That's a pretty low bar, right? I mean, anything you say could arguably lead to more questions. But the board only devotes 4 sentences to whether or not Miss Menza not being completely truthful about whether she lived currently with her first husband at the time of her interview was material. And that's really where the rubber meets the road. I mean, this is really all about materiality, all these cases a lot of the time. And I don't know, right? As you know, interview to remove the condition, the analysis is whether the marriage was valid from the start.
Yeah.
Not whether it's currently valid.
Yeah.
Is not living with your husband 2 years after marrying them is it material? I don't know. With the watered down standard, it might be. As I said on the podcast, I would have just liked a bit more analysis. And it also seems a bit unfair, right? That immigration judges don't have authority to grant an I-130, but they can de facto deny an I-485 by finding that a marriage is not valid, by denying the 485 as a matter of discretion, even though they can't approve the I-130. Now, I'm all for immigration judges being able to deny adjustment applications based on a fraud finding. But if you're going to do that, they should also be able to approve I-130s. I mean, you're stuck in USCIS who might take 2 years on an I-130 asking continuances and removal proceedings. It seems like it is a due process nightmare, and a judge is certainly qualified to determine whether or not a marriage is valid.
Yeah.
After cross-examination by ICE. I mean, it seems like a ridiculous framework to me. So if we're going to have this, you can't have your cake and eat it too, in my opinion. If we're going to have IJs essentially make 204C findings and essentially make I-130 decisions, let them approve it as well.
Be careful what you wish for. Have an I-130 interview where ICE is, following up, said there's a USCIS officer at a meeting. It makes it work. But the materiality issue, it's a nightmare because it doesn't make any sense. And it's like anything could lead to anything, but it's not supposed to be that strict. And there's history of it not being that strict. And I've seen officers go both ways on it. I've seen 601 appeals, 601s that were denied on appeal. AEO saying, you know what, this wasn't material, so this doesn't even need a 601. And I've seen cases like that. And like I have one case, I've run into cases like this, or I'm like, is it material or not? How to make determination? Maybe we should just file it and let them make a finding, and then do a 601, because I don't think it's material. So it's such a fine line of how to deal with it. I don't want to just admit to something that is not misrep, and then force a 601 waiver when it's not needed. So it's a bizarre situation.
Well, what about this? I mean, because I sometimes do this, and I'm doing this right now, although I'm not sure if I'm going to file it. I'm filing a brief. I'm filing a 601 and a brief explaining that I'm filing this in an abundance of caution. And the brief starts with a 3-page argument about why this is not fraud.
Mm-hmm.
But if you think it is, here's all this hardship. I mean, to me, maybe a USCIS officer would see that and say, I don't know. But in this case, both of my arguments are completely legitimate, and I truthfully believe that there is no fraud. But trying to get out in front of it and saying it's not fraud, that this is there, we have to concede it, but it's not fraud. Here's why. But if you think it is, let's just resolve this right now. Here's the hardship. I mean, what do you think about that? Why wait until USCIS says it's fraud without trying to get in front of it yourself?
See, that's one issue, and that strategy is like, then we need to refile an I-485 with the 601. At that point, they may go to removal and have to deal with that. But at the same time, it's like they have to pay more. We have to do all this work, and they may have waived it anyways. But then they're like, okay, we got a 601. I'm going to think about it. It's like psychology, a cost associated with it. And I've been grappling with this for a week or two, how to deal with this specific issue. We got a comment from a Facebook user saying, yes, that makes total sense. IJ's already adjudicated I-751s. I agree with you. So, going back to the drawing board, it's not that I'm talking, I'm glad we got to talk about it, especially because I don't do waivers, so I'm going to have to give it to a colleague to do. But it's a weird situation. So, I've talked with Facebook posts people about this issue too, and it was mixed back. Some would say, no, I wouldn't do it because it's not misrep, so why say it? And others are like, I wouldn't even touch that case. Some would say it's just like all over the place. It's a weird.
I like touching it. That's the most fun part about immigration for me. I must disagree with that comment, but no, I don't know. To me, like in court, right? And I know you're not in court that much. You're before USCIS more often, but even USCIS, like, I don't want the USCIS officer talking first. I don't want the ICE attorney talking first. I want to frame the issue.
Mm-hmm.
I want to be in charge, and I don't know. It's a strategy call, but to me, let me explain to you why this isn't fraud or misrepresentation, and let me then explain whatever. Let's make this the easiest way to get it off your desk. I don't care which way you go, officer. Just pick one of them. It's a strategy call, and it does make it more expensive. I understand all that.
Yeah, I'm going to think about it some more, but I'm glad we got to talk about it live in front of the whole world.